Hey, welcome everybody. Thank you for joining us for another Webinar Wednesday event. I'm Logan Arliss at Illinois Aviation Academy. And tonight's presentation, we're going to be talking about aviation law. Now, aviation law is pertinent to anybody who is connected to the operation and maintenance of aircraft. So a very important topic for tonight. We'll be speaking with Mr. Jeffrey Clement. Jeffrey Clement is a partner at Bradley, Connolly, and Masuda Attorneys at Law, and he's going to be speaking with us about aviation defense and FAA enforcement actions. Before we get into the presentation, I'd like to point out Illinois Aviation Academy will be hosting a FAA safety team event on the 5th of March at 6 p.m. here at the Academy. It's on the cost of corrosion. So we're going to be talking about corrosion on aircraft. What are the different types of corrosion? Where do they form? And most importantly, what to do if you spot corrosion on your aircraft. You guys can register on FAAsafety.gov. We hope to see you all there. And let's go ahead and bring Jeff onto the call. If you guys have any questions as we're going through the presentation, please comment your questions, whether you're on Facebook or YouTube, and we'll make sure that we get to everyone's questions at the end of the presentation. So let's get into it. Hey, Jeff.
Hey, can you hear me okay?
Hey, I got you loud and clear. Can you hear me?
Yes, I can.
All right, sounds great. First, Jeff, just want to say thank you so much for taking the time out of your night to educate us on aviation law.
Thank you.
Awesome. So we're going to be getting into it tonight. I got to ask you, so where did the passion come for aviation and where did the passion come for law, and how did you mix the two together?
Well, it was kind of by chance. I became interested in being a lawyer in college. Wasn't sure what I wanted to do. I took a business law course and realized that I found the legal profession to be much more interesting than the other stuff I was studying. Now, as far as aviation, I don't have a specific piloting background. However, around my second year of law school, I got a job at a small aviation firm. And I'd never even thought about it before, honestly, the idea of combining those two fields. And, you know, those cases are just great. They're really interesting. And as I'll explain to the group, the kind of cases we handle, and I think they'll find that it's something that people don't think about too often, but it's, it's not your typical personal injury type litigation.
Yeah, absolutely not. Yeah, it seems to be a small niche market, and, for attorneys, there's not a whole lot of attorneys who specialize in aviation law out there. So it's good to have connections, especially, being a pilot or an operator, managing an aircraft or even doing maintenance on aircraft, to have someone that, you can reach out to and discuss these certain circumstances with.
Right. Yeah, it does.
And so I can, are you going to pull up your presentation here, or you want me to do it on my end?
I can do it my end.
Perfect.
Is everyone in right now, or are we still waiting for people?
Yes, no, we're good. We are streaming right now, so everyone's watching us on Facebook and YouTube. So just going to be you and I on the call here, and then we'll be tracking their questions on social media.
Perfect. Well, I'll go ahead and get started. And Logan, again, thanks for the opportunity to address the group today. Also, thank you to Bob Werdrick. I've known Bob for many years. The purpose of my presentation today is kind of twofold with aviation law. The first is to kind of explain what an aviation lawyer does, so the audience here knows when they need a lawyer. The second is to kind of explain, maybe pique their interest a little bit in law if they are perhaps interested in combining their love of aviation with a legal career. They can kind of know what's out there, what kind of cases you'll be working on, and like I said, figure out if that would be a good fit for them. So let me get my presentation up now. Okay. All right, let me get. All right, you seeing that okay?
Perfect.
All right, well, everyone, this is a professional photo of me, which I like a lot. So you see me now on Zoom and a professional photo. So as I said, this presentation today is on the aviation law. I'm a partner with the firm of Brady, Conley, and Masuda here in Chicago. I am the chair of the Civil Practice Department. And as I said, let me give you a little background about myself. I'm from Florida originally, grew up in Central Florida, attended Florida State University, and apparently wasn't pleased with the extreme heat weather, so I decided to take a 180 and go to the extreme cold of Chicago. And I've been in Chicago about 20 years. I went to DePaul University College of Law. I got my law degree, which is called a Juris Doctor. I got my MBA at the same time. They have a joint program there. After that, I started as a clerk and then became an attorney with a small aviation law firm. And I would say we probably did about 99% aviation work, mostly general aviation crashes, transactional disputes, kind of the whole 9 yards, lots of FAA enforcement. But that really gave me some exposure to aviation, the regulatory background of the aviation business. More recently, I accepted a position with Brady, Conley, Masuda. As mentioned, I'm the chair of their civil practice group. And my current practice is a little more varied. I do, in addition to the aviation type work, a lot of cases in construction, premises, product liability. So it's a little bit of a wider scope at this time. I still do business aviation type work, which I will explain to you during this presentation what that means. FAA enforcement, which I think is something of specific interest to pilots, because this is probably the thing you worry about the most. Insurance coverage, because any kind of litigation always involves insurance, and as well as any kind of business aviation work that we do. You do not want to be flying out there without the appropriate insurance, and making sure that you're being defended and covered if worst case scenario something does happen.
Absolutely. So out of these practice areas that you most commonly work with, where do you see the most cases coming from?
Well, for overall, and these are kind of like the overall types of cases, we have your litigation. That would probably be the first most things that aviation attorneys do. A personal injury lawsuit. Someone gets hurt at an airport, on an aircraft. There's some property damage. Let's just call that litigation. The second thing we probably see most often as an aviation attorney is FAA enforcement. Now that has been declining in recent years, and I'll explain that in more detail, but the FAA has a new compliance philosophy. So there's less of this, but it's still out there. The third type of work that I do is business aviation services. This is helping people put together purchase agreements of aircraft, lease negotiations, airport leases, tenant leases, things like that. And having an aviation background is very helpful in that. I mentioned in-house. If we have time, I'll mention some jobs that will be available in-house for aviation companies, airports, things like that. But as far as I'm concerned, litigation tends to be 90% of what an aviation attorney does. Maybe 5% for FAA enforcement, maybe 5% for business aviation. But the day-to-day is usually litigation in some form. Okay. Now let's kind of talk about litigation generally. The main type that you see in a courtroom is personal injury or property damage litigation. This is the kind of thing where you probably see the commercials on TV for the plaintiff's attorneys. Usually those attorneys are like construction lawyers, or they're people who are doing nursing home type work. You don't typically see plaintiff's aviation attorneys advertising in the same way. They're pretty well known. There's a few firms that do a lot of that kind of work. Clifford Law Group, you probably see their ads all the time. You see other firms that are in the news. And you'd be surprised how big of a hub Chicago is for aviation litigation. I mean, Chicago, Florida, Texas, California, that's really the hub of aviation attorneys, and it's a small group that do it. And a lot of the attorneys from Chicago fly all over the country to handle cases, not just in Chicago, but in other jurisdictions. So Chicago is a good place to be if you're interested in being an attorney. It's not such a great place to be if you're a defendant in the lawsuit. Chicago is pretty notorious for very plaintiff-friendly juries. So people, people are rightly afraid of what happens if it goes to trial on an aviation case, worst case scenario. That's why a lot of cases settle. So that's the plaintiff's attorney. Now they're typically representing the injured individual or the company. They usually do it on a contingency fee basis. So only if they win do they get any money from the client. The defense attorney, and this is why I talked about insurance. Usually we are hired by an insurance company to defend the company that's sued. So if you're an aviation company or you own an aircraft, you would definitely want to, you're required to in fact, purchase insurance, not just for the whole of the aircraft, but for also liability coverage. So if your passengers get injured, someone on the ground gets injured, you would have an insurance policy, and part of that insurance policy is the insurance company has a duty to defend you. So if you get sued, they hire the attorney. So the insurance companies really do control who's getting cases. And I think you mentioned it too, Logan, this is a niche practice area. So I'd say, I don't know, less than 10 firms do it. And it's when I first started, I think it was solidly 10. Now I would say it's less than 10 because, and there's good reasons for that. The good reasons, and what I'll explain is, there's not a ton of aviation accidents because of the safety record of the industry and self-regulation. And so unlike in the 1980s or 70s where there were accidents on a regular basis, similar to a car, or even trucking, your typical catastrophic loss is not a typical thing to happen in aviation.
Absolutely. So while we're on litigation, so let's just say, Jeff, hypothetically, I'm involved in a aviation accident with my airplane. What should my first steps be after this accident? And, how would you go about defending me, and what does that process look like?
Right. So the first thing you want to do, as I mentioned, is the insurance company. So first call should be to your insurance company to notify them of the case, because they may hire a lawyer for you right then and there to come out, give you advice on what to do, what to preserve. That's even before you've even been sued. You should also, and we'll talk about this in a little more detail later, make a NASA report. Assuming it was inadvertent, you have 10 days to do that. And worst case scenario, there's some sort of enforcement action against you and your certificate. That may come in handy depending on the nature of the accident. There's also some rules from the NTSB about notification of an accident. It's found in 49 Code of Federal Regulations, 830. There's certain types of accidents that need to, where you need to notify the NTSB, substantial property damage, serious injuries. Now, given the fact that there's no secrets nowadays, the NTSB pretty much knows immediately when something happens, but just keep that in mind. They may ask you to fill out a form. In the past, it may have been possible to have an aircraft accident and the NTSB not know. Probably not the case so much nowadays, but you want to keep that in mind. So as far as how we defend it, it would be, and I'll go through how litigation works in general, but as I said, the insurance company typically hires you to defend it. You would have a full process of interviewing people, doing discovery. But before I get into the general framework of a personal injury lawsuit, let's talk about the type of cases that at least aviation attorneys see. Mm-hmm. The main one is, the catastrophic aviation accidents. In the commercial arena in the United States, extremely, extremely rare. It's hard to even remember the last time it happened. Well, actually, everyone does remember because it's so seldom. But we had a close one recently with that engine failure, but no one was hurt. It's kind of amazing just how safe things are in the commercial arena. Now, one thing we see a lot in Chicago is accidents that occur overseas, Indonesia, Malaysia, African nations where their safety record is not good. But those aircraft have U.S. components on them, U.S. manufactured parts on them. So what you do see in the commercial arena, at least for an aviation, a serious aviation accident, is some sort of lawsuit by a foreign national against a U.S.-based manufacturer. Boeing is the big one, obviously, because they're in Chicago. Another reason why we see so much aviation litigation in Chicago is because of Boeing, and other reasons too, just because of the size of Chicago and the amount of business that's done here. So we do see that, and that is very long, drawn-out litigation where you're fighting over choice of law, venue, all sorts of things. It's a very long process. It's not a case that goes to trial within 2 years. You're probably talking 5+ years. That's on the low end. The other type of aviation accident case we see, and these are the ones I saw more often at my prior law firm, is your general aviation loss. Smaller aircraft, perhaps someone who took on more aircraft than they could handle. Someone who maybe hit an obstruction, either leaving an airport, maybe went off the runway coming in to an airport. So we saw a lot of cases where, usually takeoff or landing accidents, also spatial disorientation type cases where people, they crash in the field and we don't know why, but that tends to be the typical cause. And usually it's due to lack of training from the pilot, or a pilot, maybe, sometimes these people, doctors, lawyer types, they think they can handle an aircraft and it's just too soon for them to do it. There's too many components, too many different factors, and they're not ready for it. So although we see general aviation accidents, we don't typically see them involved with commercial pilots. We see them with private pilots who are, doing some work. There are some exceptions. Common defendants in these kind of cases would be the aircraft operator, but with a private pilot, that's usually the same person as the plaintiff. So they have to find someone else to blame for it. So they look at the aircraft or the component part manufacturer, like we mentioned before. There are certain statutes that are proposed that prevent those kind of suits after 18 years in the United States, because some of these aircraft are very old. They may sue the airport. I can say from experience, having defended lots of airports, those are tough cases for them to prove that the airport did something to cause their accident. Usually it's subbed out, maybe a de-icing issue. That's usually done by a third-party vendor. Another defendant we've handled is air traffic control operators. Some of those towers are privately owned companies that run them. Some are run by the FAA. But for example, a mid-air collision, the pilot crashes on landing because they were confused by some directions. It's a typical defendant who would be in the case. I mentioned fixed-base operator. That's a very, as you know, Logan, a very broad term for any kind of aviation service provider. Let's say there's a misfueling incident, de-icing. Someone who maintained the aircraft at some point. They usually get roped into the litigation at some point because they want to, plaintiffs' attorneys want to be very, very careful. First, they don't want to commit malpractice by not naming someone, and they want to try to get every, potential source of funds for their lawsuit. So they name as many people as they can within reason. Not all of the cases an aviation attorney handles would be aircraft accidents. Like, for example, I mentioned premises. We would sometimes handle just straightforward slip and fall on an airport. You don't need to be an aviation attorney to do that, but that's something that regular any kind of personal injury attorney does on a regular basis. And there's really no major difference how an attorney would defend that or prosecute that at an airport. One thing about airports is they are regulated by Part 139, so that does raise one issue that needs to be researched. Now, the other type of personal injury case, I mentioned property damage. So, putting aside, I call it ramp rash, and this picture is not would not be considered ramp rash. Something much more similar. But certainly, we see aircraft hitting raised manholes, or another aircraft running into another one. Maybe no one's hurt, but there's property loss. One more serious one was where the aircraft went off the runway. Aircraft was rendered a total loss. Thankfully, no one was hurt, and it was just a property damage case. But again, as the defense attorney, it's the same issues. It's why did it crash? As a defense attorney, you're trying to usually put it on the plaintiff or the pilot, saying that the accident was caused by them. Indeed, since the pilot has the ultimate responsibility, that's usually a pretty good argument, but it doesn't always work out that cleanly.
Yes, like you mentioned, I mean, a lot of accidents are, it's that Swiss cheese effect, right? There's a lot of, hands involved. So it could be part the fixed operator, part the airport, part the operator. So in litigation, I mean, are you trying to pin it on one point, or what if there's multiple factors involved? Who's liable, and how do you determine to what degree they're liable in for that accident?
So the jury is going to ultimately decide that, but as a defendant, I'm putting it off on the plaintiff primarily, but if there's other defendants in there and the theory the plaintiff has against them is stronger, I'm going to pile on, onto that, as long as it's not related to the theory against my client, because plaintiffs love it when defendants point the fingers at each other because it's a guaranteed win for them. So you have to be very careful, and it depends on the facts. If it's truly distinct, like someone, maintenance provider failed to put the right part on and that caused the accident, yeah, then I'll pile on that. But otherwise, defendants generally want to be, focusing on the plaintiff, because that does come off the top of any recovery that the plaintiff gets. So if the jury says the pilot is 40% responsible, even if it's a big case, that's a lot of money coming off the top there.
Right.
So like I said, there's a lot of factors that go into that. It depends on the facts. But as I said, there is that big point of you don't want to be pointing, if you go to trial and your only defense is it was them, and then their defense it was you, that doesn't help.
Right.
Another type of litigation, I'll just go through as quickly, as commercial disputes. This is what we, if you're an aviation attorney, you're going to get contacted by people who have aircraft lease disputes, problems with their management companies. A knowledge of aviation helps with that. It's typically contractual type work. A more difficult case is usually an engine failure. You'll be getting into a dispute with the manufacturer regarding warranty. Those cases can get really messy and are not clear cut. You also will get involved with, for example, mechanics or storage liens. So the FBO does some work on your aircraft and they don't feel like they've been paid. They can put a lien on the aircraft. Same thing with the storage. If some place is hangering your aircraft and they've not been paid, they will put a lien on the aircraft, which is basically a claim against the aircraft. And what happens then is your bank will come and take repossession of the aircraft. So, so those get pretty heated. I won't go into too much detail, but not as interesting as the accident cases, but it does happen. All right, so we talked about how we defend a case. So this is a long process, and this is about as simplified as it gets. But as I said, aviation cases in particular are very long. The plaintiff files a complaint against defendants. They'll say why they think the defendants are responsible. There'll be various different theories. The defendants get a chance to either answer that complaint or move to dismiss it. In an aviation case, that can get very, very long process, because sometimes the accident occurs in a different location from where the litigation is, and you got different providers and different defendants that are located in different jurisdictions. So there will be jurisdictional fights that can sometimes go on for years. I think there was one case we had before we even got to any discovery. It was maybe 4 years just fighting over the jurisdiction of it. So that's something very peculiar to aviation, and you won't see that in any other type of litigation that I can think of off the top of my head. There's probably are some cases, but products cases where foreign manufacturers are involved. But you see this more often in aviation than anything else. Discovery, and I would also add fact investigation is a big thing that attorneys do. You're going to meet with your client. You're going to meet with witnesses, find out what they know. You can send what they call discovery requests to the other parties, find out what witnesses they're going to be calling, what people know. You can do what's called a deposition. We do a lot of those as attorneys, where you sit someone in front of a court reporter and the attorneys ask them questions. That's what attorneys do a lot. I'm gonna be doing that all day tomorrow, is depositions, because you get these witnesses lined up and you ask them what they know, try to get to who's most responsible for the accident. There'll be naming of experts, particularly in aviation. That's a big issue. So there'll be expert discovery, where experts will be disclosed to give opinions on the cause of the accident. Then what typically happens, and this could happen any time in the lawsuit, but usually after either the initial round of discovery or after expert discovery, there'll be it's not mandatory, but usually there'll be non-binding settlement discussions or mediation. So the parties will see if they can settle the case. I think probably everyone's heard that the statistics are well into the 90s that most cases do settle. The attorneys are experienced on these cases. They keep track of jury verdicts. They keep track of what juries are doing. And usually attorneys can kind of figure out where things are going to go. So who's responsible. And usually the attorneys can put together a deal and put it to bed. Doesn't always happen, but you've probably seen some things recently. There was that $44 million verdict against Chicago for basically a private dispute between police officers. Well, that went to trial, and for a $44 million verdict. Now that was a reverse on appeal lately, but it shows you the kind of danger with going to trial on something unless you absolutely have to. Mm-hmm. So people do try to settle it. Some plaintiffs' attorneys really push hard towards trial, but even they, once it gets, if the offer is good enough or if it's fair, they're generally best served to accept a good settlement offer versus taking your chances at trial because of the unpredictability of what can happen. You never know what a jury's going to do. Right. You can guess all you want, but it just depends on the people in that box. So then there's the trial process, which, on an aviation case, you're probably talking 6 weeks or so for trial, where you would just do what you see on TV. Except on TV, they usually go to trial after like 2 days after doing a case. And in real life, it takes years, especially on the aviation cases. Even regular slip and falls, car accidents, usually it takes at least 2 years to go to trial. But an aviation trial is a very expensive process, where you would impanel a jury, put on your evidence, do all the things you see on TV, make closing arguments, and the jury comes down with their verdict. After that is usually post-trial motions, where everyone tries to get the judge to throw out the ruling for various reasons, and then you can pursue your appeal rights, which I won't go into because again that's getting a little too nitty and gritty, but that's just the kind of the basic of how a lawsuit goes. Now, I think that Logan probably has a lot of questions at times during this, but let me just kind of, before he gets into some of that, talk about the second most area that I see as an aviation attorney, which is FAA Enforcement. And this is of particular interest to the audience, I'm sure, as a pilot. This is where the FAA accuses a pilot or an aviation company of violating the federal aviation regulations. The two main types are something against the license of the pilot or aviation company, or a civil penalty. So you're talking about either your license getting suspended or revoked, or a monetary fine that the FAA is charging against the airman or the company. So this is a little different than litigations. It's a more streamlined process. Just generally what typically happens, and I'll respond to some more specific questions, but you'll have an informal conference with the FAA about the allegations. If it doesn't resolve at that point, you would have to go to a trial type hearing before an administrative law judge. This is similar to what we call a bench trial, which is just a judge is making the ruling. There's no jury. So it's much more streamlined. Usually it doesn't last more than a day. I've had a couple that have gone 2 days. And there's two different procedures. If it involves your license, there's a special procedure where an NTSB assigned judge will make the decision. And then if it's a civil penalty matter, the FAA actually will internally have its own judge decide, which doesn't seem very impartial, but that's the way that they have things set up. Okay.
So if we back up just that last slide as you're going through the different trial and the procedures, I know it. So in terms of a lawsuit, let's say after an accident, it takes the NTSB quite some time to investigate an accident. So is that before you go to trial, is that something that you needed? Do you need that NTSB investigation report prior to going to trial for, let's say, a lawsuit or something?
So the NTSB report itself and the findings of the NTSB is not admissible, but the individual facts in the report can get into evidence. It's called the governmental exception to the hearsay rule, where you can actually introduce that. Facts, individual things that people said, stuff that would be admissible anyways, that the NTSB found. In a lot of cases, the NTSB kind of sets forth all your defenses. So sometimes, you come into a case, it's 2 years after the accident, they usually filed within 2 years. That's the statute of limitations. The NTSB may be done with its investigation, may have already issued its report, usually, which is favorable to the defendants. Usually it's a pilot error is the most common thing. There are times where the NTSB will find fault on another party. Now that conclusion, though, does not get into, the jury never hears that.
Okay.
But like I said, it does set the tone for what's going to happen. Some of the same evidence that's in the report, the defendant is going to want to go after that right away and make sure they've found those witnesses. They have the same information that they can present to the jury.
Absolutely. And then another question is, so we think of the FAA, NTSB, so the FAA regulates, the NTSB investigates. What's the distinction between the FAA and the NTSB in terms of when it comes down to aviation law?
Right. I mean, I think you said just right there, the FAA is essentially the entity that is charged with regulating and enforcing aviation safety. So the FAA has their own regulations, which if they are violated, you can either be subject to a license suspension, revocation, or a civil penalty. The NTSB can't do that. The NTSB simply is charged with investigating accidents. So there is one exception, which is, as I mentioned, with the license actions, the way the rules are set up is the NTSB judge will make the findings on that. So although the FAA is one who files the complaint against the airman for either to revoke or suspend the license, the NTSB will decide, and it's supposed to give it be more impartial.
Absolutely.
Yeah, as I mentioned, with the civil penalty, though, that's not the case. The FAA internally will decide that.
And then we had one question come in on terms of jury trials. Are there any cases that are more likely to go to a jury trial?
I would say the commercial type disputes are more likely to go to jury trial. Okay. I found in my practice, the ones where I have to take it to trial are smaller cases where it's an all win or all lose type thing with the contract, where there's enough of a dispute where both parties are willing to throw their hat in and say, well, maybe it's worth it. With the big personal injury cases, that's not usually the case. There's a lot of risk there, particularly if there's a passenger who's injured. Those don't go to trial too often. If anything, the airline may pay the passenger's claim, and then they call it a subrogation action, will chase other entities to get some of their money back. So those, like I said, the smaller cases, the disputes between aviation companies, that's where you'll see a trial more often than with the personal injury stuff. Like I said, slip and falls, that could go to trial, but it isn't that specific to aviation. It just would be like any slip and fall that you handle at a premises.
Right. All right, then I got some more specific questions for you on FAA enforcement action. So one of them, let's say, what if the FAA has denied me my medical certificate? Can an aviation attorney assist me in this situation?
Yes, an aviation attorney can. Similarly, there is an appeals process relating to an FAA's denial of the certificate, and it also goes to the NTSB. There would be a hearing before the NTSB administrative law judge. I would caution a couple things with medical denials. It's a little more difficult, to get a win on that. You can only appeal the denial of an unrestricted certificate. If you're trying to get a special exception from a disabling condition, that is not appealable. It's considered completely discretionary by the FAA. And you also have to realize that if you are going to take that to hearing, you're going to need to get your own doctor in there to support the fact that you are completely qualified despite whatever medical condition they feel that whatever medical condition the FAA examiner felt disqualified you. So it's going to be a battle of medical experts. Keep in mind that the NTSB judges have seen the FAA medical examiners before. They probably like them. They probably trust them. So that would be my caution with the medical appeals is not, it's a little bit more difficult to get a win if you're going to pursue that.
Yeah, it sounds like an uphill battle.
It is.
The next question is, how does the FAA calculate civil penalties? What are some situations where the FAA would impose a civil penalty? And then how would an aviation attorney go about defending you in this situation?
Well, the civil penalty, the actual amount, there's actually a handbook that the FAA publishes for its attorneys to reference. It's called the Compliance and Enforcement Program. Order number is it's an FAA Order 2150. It can be found online, and they basically will say how they calculate the penalties, what minimums, what maximums they are. It will depend on the severity of the type of violation. It will depend on whether you're an individual versus a small business versus a large business. They can look at aggravating circumstances, like, for example, if it was intentional, or if you've had prior violations, or they'll look at mitigating circumstances. This is your first time, it was inadvertent. You didn't realize you were violating the rules. So usually the FAA attorneys are pretty strict about trying to follow that to the best extent they can. Mm-hmm. The process for civil penalty is similar to the certificate action, except the fact that you go for a hearing before the FAA. You do get the opportunity to do an informal conference. Most cases settle at the informal conference with the FAA, where you sit down with the attorney and explain your side. So there'll be some back and forth and some negotiation. Usually you can get the penalty reduced, or hopefully even better, than to drop it. I do want to mention that the FAA, at least years ago, had issued new guidance where their main goal is compliance. So the more you can try to show you have a compliance-friendly attitude, the more you can try to explain to the FAA that you have corrective action that would prevent this from happening again. That this gives the FAA a little more discretion now to not say, okay, well, maybe they did violate the rule, but I'm going to let it off this time. We're going to do this as some corrective action, and we're not going to pursue this further. So that has changed the practice a little bit. Mm-hmm. We do see less enforcement actions because of it, and we see more settlements. And I think this benefits airmen quite a bit because I don't think it's fair to have something on your record if it's your first time, you didn't know. You can easily rectify it for the future. The guide is always so people get better and are safer, and the more that people can self-report, the more they can fall on the sword and say, I messed up, I want to fix this. It's more similar to what has been going on for a long time with commercial aviation, where it's all about corrective action. So right. So basically, the pilots, if they make a mistake, they immediately report it. Now they have to do a lot of training afterwards, make sure it doesn't happen again. But at least they don't have anything on their record.
Yeah, that's nice. Now the dreaded 709 ride. So the FAA's requested I take a 709 ride. Would it be beneficial for me to consult an aviation attorney if I'm requested to do this? And then what are some of the common reasons you've seen the FAA request 709 rides?
Well, you could certainly consult with an aviation attorney to give you some additional advice, but I would mention the FAA has free reign to request these rides. So you have to comply. If you don't comply with the request, you'll lose your license on an emergency basis. So you do have to do that. The most common trigger is the FAA became aware of some sort of incident or report involving the pilot's competency or something they did. So they have some concerns as to whether you are actually qualified. They think you maybe have missed something in your training or you don't understand something. So, you know, like I said, you can talk to an aviation attorney. This is what I tell you is that you need to cooperate. You should contact the FAA inspector who requested or the examiner who requested your check, or excuse me, your 709 ride. Getting a clarity as to exactly what they want to test. Now they usually will put that in their letter, but make sure you understand. Get it scheduled, but give yourself enough time to get in front of your favorite CFI together and train. Be prepared. Consider it a test, because if you fail it, you might get the opportunity to try again, or you may lose your license. So consider it the chance to get better. If you fail the 709 ride once or twice, maybe it's time to think about a different career. But to just like anything in life, you got to study. Yep. You got to get your CFI. You got to do your training.
Good advice. Now, let's say that I have a bad flight, and I know I did something wrong. Let's say I flew up and us at DuPage were right underneath O'Hare's airspace. Let's say I broke O'Hare's airspace or inadvertently violated a TFR, busted an assigned altitude on an IFR flight. I know I broke the rules. Say I got a number from tower to call, that dreaded communication. I got a number for you to copy. What should I do in this situation? And then this kind of brings me, we mentioned it before, the whole NASA report. So what is the purpose of that NASA report, and will it help my case in this situation where I know I've broken the rules? I've heard to it before, people refer to it as a get out of jail free card. I don't know if I would want to refer to it as that, but can you talk to me a little bit about this situation?
Yeah, I'll start with the NASA report because I do think that's the first thing to be thinking about. If it was inadvertent, the NASA program is very helpful. It's called the Aviation Safety Reporting Program. There is an advisory circular that explains how it's done. So if you have inadvertently violated the FARs by mistake, or you think that someone else believes you've committed a violation, you can file this thing called a NASA report. It's a form, and it will give you essentially immunity from the sanction. Let me explain what that means. The FAA can still bring an enforcement action against you, and if they're successful, there could still be a notation in your record of a finding of a violation. But the positive thing is you do not have to actually suffer the consequences as far as, let's say, the remedy that FAA sought was 30-day suspensions. Well, you don't have to sit out, for 30 days. You can continue to use your license because that's what they mean by get out of jail free card. I don't really think it's a get out of jail free card. I think it's just to keep you in the air, and especially if you want to stay. If you're someone who flies regularly, you don't want to be sitting out for 30 days or 60 days, or even worse, if there's a revocation. Keeping in mind that revocation is for more serious, so the FAA may not consider that unintentional. They may not accept the NASA, and you got to fight with them about that. But your example, the airspace violation, it's inadvertent. We used to see this all the time. We used to always have to defend them, and you take them all the way to the end, of informal conference. Because of the new guidance from the FAA and the new, methodology for trying to have corrective action, we're seeing less of those where the FAA actually tries to get a remedy against the airmen, because it's more of like, okay, let's train you more, about this so you don't do it again. But anyway, and back to the NASA report, you're supposed to do it you have to do it within 10 days. You got to keep your certified return receipt to show you mailed it out, because you have to prove it as a defense. And usually we present that to the FAA at the informal conference. We say, here's our proof of a NASA report. And they'll tell us whether they have any issues with the proof of it. Keep in mind, you can only use this once every 5 years. So, you can't keep filing a NASA report every day and thinking you're going to get away with it. It's once every 5 years. So they'll keep track of that too. And again, it's all for aviation safety. So NASA, NTSB can keep track of what kind of incidents are happening and improve training. Let me go back though to, let's say, putting aside the NASA report, the first thing you can expect as a pilot is a letter of investigation from the FAA. We call it the LOI. This is where you should get an aviation attorney involved, because this means the FAA is preparing for enforcement against you. They're getting data against you. They may seek a remedy against you, either penalty or revocation or suspension. There are changes to the law of the last 10 years with the Pilot's Bill of Rights. If it's an air navigational issue where radar data might be relevant, because of that change, you now can request that data right away. As soon as you get that LOI, you can request the air traffic data and get it, so you know if they have something on you, basically. That did not tend to be the case before. The Pilot's Bill of Rights, they also have to advise you that you don't have to respond to the letter of investigation. It's sort of like a Miranda warning. Hey, if you do respond, we could use it against you. And the way we advise people is, we kind of play both sides with that, because you do want to respond to the LOI. If you don't respond to it, it's going to go forward without your input. But you don't want to admit to doing something that's going to give them their case. At the same time, if you can propose corrective action, so the FAA can kind of derail this into the corrective action and not enforcement, given their new policy, then that's the goal we look for. And it just depends on the FAA attorney who you're dealing with. It depends on the inspector who thinks there was a violation, the FAA's prior experiences with you or your company will kind of color how they handle it. And I've never seen like it always happens this way. Sometimes I'm surprised that they let things go, and sometimes I'm surprised that they continue with the case, because our client may be very compliant and very well respected, but sometimes for whatever reason they take that. And then after that, as I mentioned here, the streamlined process. You have your informal conference, and if necessary, your hearing.
All right, my final question in the FAA enforcement section. So get done with the flight, and I get the FAA representative come up to me and say, "Hey, I'm with the FAA. I'm here to help, and there to perform a ramp check. What should I do in this situation?"
Well, this is one of the worst situations, because you have to be careful. They are authorized under their order to do a ramp check of you for various reasons. You're only required to present paperwork they request. If they want to see inside the aircraft, you do not have to give consent to that. You can tell them no. At the same time, they, as an aviation safety inspector, have to be careful too, due to the Pilot's Bill of Rights. If they're doing this ramp check for enforcement purposes, they really should be sending you a letter of investigation explaining what they're doing. So they're walking a close line too. But for non-commercial operations, all you have to do is give them the paperwork. If you have logbooks, if you have your medical, your license, aircraft data, things like that. Be polite to the FAA inspector. You don't need to volunteer information. It's easier said than done. I mean, if you're there with someone in your face, you're going to try to, you're going to try to say, "I didn't do anything wrong." It's natural. But like I said, consider doing a NASA report. If you think that they found a discrepancy, consider doing that NASA report within 10 days. If you're working for a commercial company and you're getting ramp checked, you certainly want to call your boss. You certainly want to, they may want to get attorneys involved. but you don't want to seem overly concerned either. If you don't have anything super to be concerned about, then you want to let the FAA have some access and be as polite as possible. But just keeping a close check on what you think they're going at. If they're going at something where you think they find a violation for some reason, file that NASA report.
Absolutely. Good advice. We had one other question come in regarding the FAA's legal team. How big is the FAA's legal team?
Well, it depends on the region. It used to be handled by various regional council offices. There was the Great Lakes region before. I don't know the numbers off the top of my head, but there used to be 9 regional council offices. With the change, and this may have changed recently, but a few years back, they basically have everything under the office of chief counsel. And there's 5 different enforcement divisions. There's one Midwest enforcement team, which will have a few lawyers, and they're actually here in Chicago area. I believe Des Plaines is where it is. But there's several attorneys over there who handle these kind of cases. Kind of like I said, though, because of the new, even though I can't give you numbers, I do think that because they're going more towards compliance and corrective action, those attorneys are a little less busy as far as often, trying to prosecute airmen. It's more, it's just a little friendlier process, and I think it's all for the better because it's worked very well in commercial aviation, and it should be the same. It should be the same for private pilots or general aviation. So, people aren't trying to hide what they're doing. People are trying to comply and trying to get better. That's really how you promote aircraft safety and protect the public.
Absolutely.
And before I go, I want to mention a couple other types of legal work that aviation attorneys do. Business aviation is one of the services that I provide. So let's say you've got an aviation business, or you want to lease your aircraft, you want to hire a management company, or if you're going to start a management company, attorneys can help with negotiating that. If you have a corporation that wants to purchase an aircraft for use in its corporation to fly, shareholders around or employees around, you want to talk to an employee because there is a unique regulatory and tax scheme in Illinois that you have to take into consideration. So it's very complex and something that you want to talk to an attorney about who handles that kind of thing. Aircraft purchases, you always want to, just like when you purchase a home or a condo or whatever, you want to get an attorney to review it. Unlike home purchase, a big issue with aircraft purchases is the scope of the pre-purchase inspection. You got to make sure there's plenty of the usual liability provisions. But, again, that's where an aviation attorney can come in hand. So even though most aviation attorneys do litigation primarily, we all also do these other services as well, just as a function of knowing that business. My last slide is I wanted to mention for those of you who might be interested in becoming a lawyer, there are in-house jobs in aviation. For example, for governmental agencies, most airports are city or county owned. So you might have a city department of aviation. As the last question, there's FAA Legal Team, Chief Counsel, Regional Counsel, Enforcement Attorneys. Having an aviation background, or being a pilot is a huge plus for any of these things. You could work as an attorney for an airline or a manufacturer, pilots union, lawyers. So there's a lot of opportunities out there, even though aviation law is a niche field. And I would mention for any of you who are interested in law that having a pilot's license is very attractive to the few firms that do aviation work because it's becoming increasingly rare. Aviation attorneys from decades ago had military service back when there was a draft. They may have done the Air Force. That's no longer the case. So it is a heads up, on competition if you want to get into that field. With the qualifier that there's not a ton of firms that do that type of work. And if you're still interested in aviation law, well, the first steps would be to obviously get your law degree. It's a 3-year post-college degree. You have to take the dreaded bar exam. If you're interested, think about joining an organization. There's the Lawyer Pilots Bar Association. They have a nice periodical that they publish. National Business Aviation Association, NBAA, that's an organization that provides kind of lobbying for business aviation interest. Chicago Bar Association actually has an aviation committee, and it is open to the public. And we do from time to time see pilots come in or people who are just interested. You don't have to necessarily be a member of that, but we do have people come in just to see what it's all about and to learn about it if you're interested. And if anyone has any questions, let me know.
Awesome. Well, I think we got to all of our questions on our end. Really appreciate you taking the time out of your night and sharing your expertise on aviation law with us. For everyone back home, always good to have a aviation attorney contact. So make sure you jot down Jeff's number here in case you run into one of these situations that we talked about tonight. He'd be happy to consult with you. So Jeff, thanks for your time again. We really appreciate it.
Thank you. Good night.
All right. Have a good night. Have a good night, everyone. Thanks for joining us. We'll see you next time.